Fourth Amendment against unreasonable searches and seizures extends to investigative traffic stops, known as Terry stops, after the Supreme Court case of Terry v. Ohio. The touchstone of the Fourth Amendment is reasonableness. This reasonableness requirement strikes a balance between the public interest of protecting the roadways from drunk drivers and the individual's right to personal security free from arbitrary interference. Reasonable suspicion justifies an investigative stop if there are specific, articulable facts supporting the inference of criminal activity. There is not a clear set of legal rules to establish what reasonable suspicion is, but rather, as the United States Supreme Court described, it is an elusive concept. In determining the reasonableness of a stop, the evidence is viewed under the totality of the circumstances in the context of the law enforcement officer's training and experience. This permits the officer to stop the person for a brief time and take additional steps to further investigate, so long as it is reasonably related in scope to the circumstances which justified the initial stop. Our courts have held that a stop based on a belief that a driver has committed a traffic infraction is reasonable suspicion. Usual conduct is swerving in the travel lane, driving on the shoulder, straddling the lane, crossing the center lane, or weaving in and out of traffic. Stop may be justified where no reasonable suspicion exists under the community caretaking exception, when a police officer has an objectively reasonable belief that a driver is in need of emergency assistance. For example, there's a medical emergency, or whether or not it presents a safety hazard, for example, if the car doesn't have functioning brakes. This initial stop, even absent the reasonable suspicion usually required, could lead into a DUI investigation if the police encounters any indicia of drinking, for example, the odor of alcohol, bloodshot eyes, etc. If the initial stop was not justified, then everything that follows, field sobriety tests, statements made, may be excluded as fruit of the poisonous tree.